is Ali Talai. I'm an estate and trust attorney here in Woodland Hills, California. And today, this video that I'm making, I want to talk to you a little bit about how important it is to update your estate plan. The topic of the webinar is don't let your estate plan get old. It could cost your loved ones. Just to tell you a little bit about myself, I am an attorney. I have an advanced tax degree. And my goal really here is to be able to provide lots of great estate planning tools and ways to go about doing the estate plan. Having a comprehensive estate plan is something that I think it's essential for many people. All right, we are on multiple different platforms. If you're watching this video on YouTube, I ask that you give it a thumbs up, maybe post a comment for us, and it'd be great if you share this with somebody else that you know that is looking to do their estate plan. We're also on the other platform like Instagram and LinkedIn. It would be great if you follow us there if you're looking to get more information about estate planning, trust planning, asset protection, estate tax planning, everything to do with these sort of things. We post pretty regularly. All right, let's talk about this whole webinar and talking about, not letting your estate plan get old. And we all, before we get into this whole thing, we want to find out what is the goal of an estate plan when you put something together. Three main goals I could think of. One is that we want to avoid the state's estate plan. Every state has an estate plan for everybody that lives in that state. It's called the intestacy laws. So if you do nothing, that could be your planning strategy, doing nothing. That means you're going to be under the state estate plan. And luckily, we have the option to opt out of it by doing our own estate plan. In many, many cases, it's much better to have your own estate plan, much more flexibilities, a much better way to structure things. And it'll probably be less expensive for your loved ones at the time they're going to inherit the estate. The other goal is that we want to make sure your wishes are well known. You want to take care of your loved ones. If you have minor children, it's more essential to have these sort of plans in place. An out-of-date estate plan is in many cases worthless. Sometimes it's better not to have them than have them. Situations in which you want to consider updating your trust, updating your will. Let's talk about it. One of the first thing that happens, and it really requires you to at least review your trust, your estate plan, is at birth of a child. And a lot of times there might be a need to update, to create shares for that child and different things that are going to be required within the trust. Kobe Bryant set up his trust back in 2003 and ended up amending it each time when he had his children. However, his daughter Capri, when he had her, he didn't update his trust, and unfortunately he passed away. And it meant that Vanessa had to petition the court to have the trust documents amended to add her name to it. So it becomes essential to making sure that we do these sort of updates at a birth of a child, birth of a grandchild, which we'll discuss in a little bit. It's much easier when we're here to make these changes versus trying to now having to petition the court and having to go through the process of probate, and having somebody else sort of looking things over and making it more costly and longer to accomplish the same goal. So much easier to do it ourselves. Birth of a grandchild could be something else that may trigger us wanting to amend our estate plan. And a lot of times as grandparents want to leave something for their grandchildren. I got an example here for you. I have Ted and Emma. They have two kids, John and Adam. John's kid, who are Mary and Ellen, they're born at the time grandparents set up their trust. Grandparents want to create a trust within their trust, an educational trust that they want to fund at the time they pass away. And that fund, the funds that are within that educational trust, is to be used for the education of the grandchildren. In this case, they only name them, they name the grandchildren by name. They put Mary and Ellen. And what happens is that Adam, their second son, he ends up having a child, George, but grandparents don't end up amending their trust. They pass away, and now their intention of trying to provide for all their grandchildren is not exactly happening here, because the trust that was set up for educational purposes only names Mary and Ellen, the only grandchildren. So birth of a grandchild could be another reason we want to update these things. Unfortunate death of a family member would become something that would require us to, again, at least review our estate plan. In many cases, we're going to need to amend it or restate it, and we'll talk about what's the difference between an amendment and a restatement. Within an estate plan, you have this person who we call the will maker, the trust maker. So whoever is the person that creates the trust, that's an essential part of, member of the estate plan. Beneficiaries are essential. Also, the managers within a trust, they refer to them as trustees. Within a will-based estate plan, they refer to them as personal representative, executive, administrators. But so if you have named someone as the trustee of your trust, as a successor trustee of your trust, and unfortunately he or she passes away, it's essential to update the trust, to remove that person's name and make sure now we have somebody else named within the trust to make the administration of your trust easier at the time, unfortunately, you pass away. So the example that I have here, we have a death of a family member. Stacy, she sets up a will, names her mom as the only beneficiary of the will, and does not name any contingent beneficiary. Unfortunately, Stacy and her mother pass away at the same time. And since the will does not state who the estate would go to, then estate law would become the default law of the will, and then everything will end up going to her estranged brother. So again, we want to make sure we do a more comprehensive estate plan, and then it takes and thinks about, what happens if whoever I named as beneficiary is gone? What happens if, I pass away at the same time as the beneficiary passes away? So sort of thinking that through and having an estate plan that thinks about these things become much more important. Purchasing a new home is another event that really requires you to at least review your trust and your estate plan. If you have a trust-based estate plan, it's pretty easy. If the trust is already there, then all you do is just transfer the property into it. Or when you establish the trust, you create a deed, or in most cases, your attorney does a quick claim deed and transfers the property in there. If you don't do that, and you have a property that is under your name only, and unfortunately you pass away, then there's going to be probate for that property. If you have a trust and you still don't have the property transferred under the name of the trust, that still means that we're going to have to go visit the probate court to get some kind of an order. They call it an 850 petition or a Hexstat petition here in California, that allows the beneficiary or the trustee of the trust to be able to take the property and now acquire it within the trust, so then he or she could administrate it based on what the trust says. So again, really important to make sure you get the title of the property under the name of your trust. It's relatively easy, and it saves months and months of going back and forth through the court system if that's not done. Let me give you an example for purchasing a home. So here I have Roy, who lives in California, purchased a vacation home in Vegas under his own name. At his death, he's going to end up having to do 2 probate. And again, my example takes in, it's based on Roy not having anything done, or maybe just the will. And when something like this happens, if you have properties in multiple states, then we're doing probate in every state. So here he would have to do a probate for the Nevada property, and also he would have to do a probate for his California property. And as you could tell, this is double the work. So a lot of times the fees doubled as well. And when the expenses of administrating the state goes up, that's just reducing the inheritance that your child or your children would receive. So, these sort of estate planning we do, in most cases, we don't even see the benefit. It's really that we're doing these things for for our children. We love them so much. Everything we do is to provide for them. So the idea is that we do these things so at the time we are not here, they don't have to go through the trouble of probate process and all the stuff that is related to it. If you're listening to this webinar, this video, and you find it helpful, I want to ask you to please share the video, maybe on your social media, maybe with a friend that is looking to do their trust. I would greatly appreciate that. All right, getting married. That could be another event that we want to review our estate plan, keeping ownership of money and property straight. We want to make sure it outlines your wishes about what is left to your spouse. We want to make sure you have appointed, if your spouse is going to be the decision maker for you, healthcare, power of attorney, those sort of things. We need to make sure there are documents set up that actually allows her to do that, allows him to do that. Just the fact that I'm married to someone and he or she is my spouse does not mean that they would have automatic power to make these kind of decisions. Let me give you an example. I got here Emmett, who created an estate plan in 1999, and we're in 2023 now. So this is many, many years back. Betty was named as his agent under financial and medical power of attorney. Betty was his mom. They get married. Emmett and Lucy get married. Unfortunately, Emmett, in my example here, falls off the balcony in his honeymoon. Bad time for this to happen. I'm not sure if there is a good time, but Betty now is the only person who could make decisions for Emmett, despite the fact that Emmett is married to Lucy. So again, these sort of documents, these sort of planning becomes essential to be kept up to date. Just the fact that you got to trust is not something you check off your bucket list and say, that's it. No, in our firm, every 3 years, we like to review the estate planning that we've done with our clients. That's our default. Obviously, if something happened and we need to review it sooner, or, there's some sort of an event, this example that I'm giving you here, something like this has happened. We want to have you and have our client call us, and we could review things and make sure all the estate planning is in order. Getting divorced, unfortunately, when things like this happen, sometimes fortunately, depending how the marriage was, becomes really important. A lot of times people put their spouse as their personal representative, as their trustee, as the executor, as a beneficiary of a life insurance, of different bank accounts. And the fact that you got divorced, not in all states and not in all accounts, means that they're going to be automatically taken off the beneficiary designation form. Particularly, let's say in life insurance, if you name your spouse or your ex-spouse as the beneficiary and now you get a divorce, it does not mean that he or she is not the beneficiary anymore. You have to go back in there and change it in many, many of the states. And just to be sure and avoid any confusion and letting everybody know what your intention is, you want to lay out a clear intention by getting rid of all the forms, anything that maybe has their name on it, their spouse, the ex-spouse's name on it. So then there's no confusion. Let's talk about a trust-based estate plan. In most cases, we start with a revocable living trust. That means, as its name sort of suggests, it's a living document and it becomes a fully functioning document at the time you sign it. A will, on the other hand, even though you sign it today, it gets witnessed and dated and all that stuff. It doesn't become effective until the person passes away, until it goes to the court and a judge reviews it and says, you know what, this is the stamp of approval that this will is an effective will. That is not the case with the trust. With the trust, with revocable living trust, in many of the cases, all the inter vivos trust, that means that it's created at the time you're alive, the person is alive, and it's effective right there. That's a reason, now that we're talking about this thing, this is a reason why a will cannot have incapacity planning in there even if you write it in there, even if the attorney doesn't know and they put something in there, it's not going to be effective because a will does not become effective until the person passes away. So if I'm incapacitated, it really doesn't matter because that will is not an effective document. Vice versa, a revocable living trust, an inter vivos trust, a trust that you create during your lifetime, because it's effective right now, because it's a living document, you could have incapacity planning in there. It allows you to transfer property in there. You're still the beneficiary of the trust. In most cases, you still could be the management of the manager of the trust. But at the time you pass away, there's no probate for the asset that is inside the trust, or they're somehow tied into the trust. And the reason is, let's go back to a property. It's a little bit easier example since so many people have property. If you own a property and we quit claim it into the name of the revocable living trust, it's not under your name anymore. It's under the name of the revocable living trust. And these revocable living trusts, they get to live much longer than us after we pass away. They get to live at least another, in many cases, 100 years. And I'm talking about California statute. And that's like the shortest statute. There are like Alaska is 1,000 year, Nevada 365. So you could have a trust and live for much longer. And there are different reasons. Maybe we have a large estate and we wanted to stay within our family and avoid estate taxes, generation skipping transfer taxes, gift taxes. There's so many different reasons why those kind of trusts would be essential. Anyway, so you transfer the property under the name of the trust, you pass away, the trust is still alive. We don't need a court to appoint a manager of the trust. The trustee of the trust already has legal power to sign everything. And that's why it avoids probate. When you get a trust, let's talk about amending it and restating it. I'm getting towards the end of my video. Two ways to go about making changes. One is amendment. Amendment really, a lot of times we use it if we're making a small change. Let's say you have John Smith as the trustee and you decide that John Smith is just not the right person anymore and you want to name somebody else as the trustee. Those are an amendment would most likely would be sufficient for that. So smaller changes were okay. The other option is the restatement, and a restatement realistically restate the entire trust. Let's say I set up a trust 10 years ago, and I have properties that I have transferred into the name of the trust. Let's say I have 5 properties that are under the name of the trust. And now I go see this great attorney that is recording a video every few days on YouTube, has a bunch of different stuff on social media. Anyways, and we decide that we're going to update the trust. We're going to make lots of different changes, but I don't want to change the name of the trust, because if I change the name of the trust, that means all that 5 properties that I was telling you about, for all of them, I would have to record a new deed, transferring their name, transferring their ownership from the old trust to the new trust. So now we're going to create a bunch of work that maybe is not necessary to do. So when you do a restatement, you restate the entire trust, but you don't change the name. So the name stays the same, but reality of it, you have a brand new trust, so you could do, whatever is needed to do at that time. And a lot of times, if we're adding maybe continuing trust for children, if you're looking to have asset protection trust for your children within your trust, if you have an older trust and it has this A/B trust provisions in there, and we want to get rid of those things. So there are many reasons why a restatement would be essential. And the restatement realistically would be the controlling document. It would supersede anything else that was written previously. Amendments, pros, and restatement pros and cons. And as you could see here, amendments are shorter, simpler. The problem is then you start having lots of different documents, and sometimes they get misplaced, they cannot be found. And then beneficiaries will see everything, because all the changes they'll get to see when at the time you're not here. When we go through administration, this is all becomes part of the trust documents, and they'll get to see it. Restatement, pro is one document is needed to administrating the trust. Beneficiaries only see the restatement. And the con is that it might cost you more to prepare it. It's because we're just more work to do. And if it makes more sense to do a restatement to make sure we have a better estate plan, whatever the extra cost is well worth. And I tell you from experience, going through a lot of trust administration with clients that have trust that has 10 different amendments, and 5 of them are not there, and you know, just creates so much problems. All right. Don't forget to review your other documents. We talked about a lot of the estate planning documents, the trust and the will in this video, but reality of it is there's healthcare directives, financial power attorneys. What else can I say? Those are the 2 main. HIPAA authorization. That's another document. Legal guardian. So we want to make sure we review these documents as well, because again, they could be essential in the estate planning plan that you have in place. I hope you enjoyed this video. You have my information here. Again, my name is Ali Talai. I'm a trust and estate planning attorney. Our office is here in Woodland Hills, California. And if you're looking to maybe talk to me, if you go on our website, you could book a 15-minute call with me, and I'll be more than happy to speak with you without charging you, at least for 15 minutes, and to try to figure out, you know, do you need a trust? Do we need to restate your trust? Do you need asset protection? Do you need more of an advanced estate tax planning? We do all sorts of things as it relates to estate planning. All right. I hope you enjoyed the video, and I hope to see you next time. Thank you. Bye-bye.